We are live.
All right, welcome to House Judiciary Committee this Tuesday morning, April 14th, and we're taking a look at an amendment on S-218, the chloride or salt bill, which is, we don't have jurisdiction over this, but we've been asked to weigh in on this particular amendment because it does impact our jurisdiction. So we're going to start by hearing the sponsor. If you thank you for being here. And becoming a frequent flyer in this.
I know, you know me, I get around. It's like that song, get around. Everybody know that song?
Yeah. So by yourself for the record. All right. Tell us about your amendment.
Sure. Michael Booten, Berry City. I have 14 years of experience of municipal government as a city councilor, so this kind of stuff is very important to me. And I do want to say thank you for having me here and allowing me to run my gums a bit. And to present the amendment regarding municipal liability that we can put into S-218, the salt bill. As the bill is currently drafted, it creates what is called an affirmative defense for municipalities. However, the protection is inadequate. In order to qualify, a municipality must prove multiple conditions, including annual training, detailed record keeping, and that the incident was caused solely by snow or ice, all while still being exposed to claims of negligence. In practice, that is not a strong protection. It creates a situation where a municipality could still face significant legal exposure, and frankly, any attorney worth their weight could challenge that defense. At the same time, we are asking municipalities to reduce salt usage. While that is a worthwhile goal, we have to recognize the risk we are asking them to take on. Without meaningful liability protection, municipalities are being put in a position where a single lawsuit could have major financial impact on their general fund and ultimately property taxes, everybody that we represent. This amendment is a straightforward fix. It applies a liability cap of $500,000 per person and $2 million per incident, which mirrors the caps that the state of Vermont currently has in place and uses. I mean, it's something that they've had, and it should absolutely be extended to the municipality. For reasons of germaneness, this amendment only applies to the municipal salt applicators. I would support certainly a broader application to municipalities generally, but this is the scope that I can address with this amendment. However, I have been told that you guys are able to open it wide up, so just throwing it out there. VLCT has expressed strong support for this amendment and has described it as a necessary step to ensure municipalities can participate in the chloride reduction program without undue financial risk. At the end of the day, if we want municipalities to reduce salt use, we need to provide them with real workable protection, not something that looks good on paper, but slips and falls short in practice.
Questions for Mike?
Yeah, I can start. So, is the League of Cities and Towns in here?
Yes.
So, thank you. So there's 500,000 limit per person. What happens if they get a serious head injury? That 500 grand is used up like nothing.
It's a question that you could ask for the state of Vermont as well. I mean, Vermont already has, the state of Vermont has the same legal protections that I'm just asking for you to apply to this one bill.
Okay, so I got you there. So you've been in municipal government for how long?
14 years.
So I was in it for 10, right? And I was a stickler for spending money, which I am here, right? Like, why are we wasting salt if we don't need to? I mean, that would be that you're going to follow that on as a select board member. I assume you're
absolutely.
So, I mean, why do we need more government input on that, especially when we have VLCT to go and kind of oversee that? If your city council, right?
Sadly, I'm not anymore, but
Okay.
I was.
But in our past lives, that was part of our job to go and do. So
So
common sense.
this doesn't, yeah, the salt, certainly municipalities are going to want to reduce their salt usage because they don't want to spend the money because it costs taxpayers money to do that, and we have to pass budgets. The bill, does that in the main bill, but this amendment is solely to provide additional protection for the municipality if they do a reduction in their salt and somebody tries to file a claim.
So I get all that, like Northfield, we put in the safety, stormwater drains, whatever it is to try to, all that stuff out there, but I'm not crazy about this bill to begin with, so.
Oh, I'm not defending the bill.
No, I didn't
Please,
say what.
please be very, I'm definitely.
Where I should, I'm trying to figure out in my head how to make this workable that I can try to agree with it.
Yeah, so all I'm asking for is support on the amendment. The amendment which just increases or not increases, but puts a cap on the liability for the municipality, similar to the H-138, which is a bill that was submitted by the chair.
Thank you.
Ian and then
I
Karen.
think Karen's.
Karen, then Ian.
Yes, thank you for this amendment. And I have to say, when I first looked, I was like, yeah, this sounds like it's a good thing for municipalities. However, I'm looking at kind of constituents across the whole community. And I'm really curious about the data behind this because we have it set up that there's going to be the affirmative defense, which could protect municipalities fully. So where's the data saying that more protection is needed? And also like data on how many of these incidents have happened. Because for me, it's how do we make sure folks get the full coverage that they need when one of these rare and horrible accidents happens?
Sure. So I will say that the salt bill is asking you to lower your salt usage and putting a quasi protection in there for the municipality for reducing that salt usage. But again, any lawyer can get through those type of protections, but a liability cap is a little bit different. And for the data, I would just point to the state of Vermont because they have had this for a while, and I don't know how long, but long enough to know that at least for 2 years, VLCT has been trying to get this liability across the board. And I'm assuming that it's longer, and I would have to defer to VLCT for how long Vermont has enjoyed that liability cap and what impacts have been felt from that.
So I'll just say from my perspective, I feel like this open to hearing more, but I feel like this is a leap. Like I would feel more comfortable starting with the affirmative defense piece and let's see what are the gaps in the pieces from there, rather than jumping to this cap that could leave community members without coverage.
Ian.
Just one question. Do you know how municipalities are insured?
Yes, they're insured through VLCT.
So they're not self-insured?
They're not to my knowledge.
Some are.
Yeah, I can only speak to one, and the one that I was a part of, which is Berry City, and they're through VLCT.
Yeah. Other questions?
Will we take another testimony?
Yeah, we're going to hear from Samantha, right? And also Chris Mayer. So we'll have Samantha join us now. Thank you. Thank you very much. Thank you for being here. Thank you for being available today.
Of course. Thank you for having us and thank you for considering so carefully this amendment, which we totally support, are really happy to support. I'm just going to pull up some notes in front of me because you have great questions and I'd love to answer all of them.
Identify yourself for the record.
So my name is Samantha Sheehan. I'm the Municipal Policy and Advocacy Specialist for the Vermont League of Cities and Towns. Immediately prior to joining the league, I worked for the former mayor of the city of Burlington, Mayor Moreau Weinberger, which is self-insured. So Burlington is one of currently 2 municipalities not in VLCT's insurance pool. Leagues across the city, leagues across the country provide this type of insurance coverage where the municipalities pool together. And so PASIF is a separate organization with a separate board that governs the insurance business that VLCT provides. I work for VLCT. We represent all 251 municipalities in the state of Vermont, including the municipalities where you live and serve. And so we are really happy to support this amendment brought to you today. And if you adopted the amendment, we would be happy to support the bill S218, but without it, we're really not able to. And that's because our risk management attorneys who advise all Vermont municipalities on risk management find the current affirmative defense and liability protection, limited liability protection carried in S218 to be totally inadequate for municipal government. And so what I want to really talk to you about today is 3 things. So the first is that this is a very small, discrete change to the bill that is totally in line with Vermont state law and the protections already extended to state government. And so I'll respectfully disagree that this is a leap. This is actually a very discrete change that extends a relatively small protection to municipalities. It doesn't make programmatic or policy shifts within the bill and the SALT reduction program that it envisions creating, and is totally consistent with state law and state monetary liability caps. The second point I want to make is it talk more about why the affirmative defense in the bill is not adequate for municipalities specifically. And then lastly, just talk about how this amendment would really improve participation in the program at the municipal level. So the way municipal liability works and our sort of relationship with tort law compared to the state goes back a number of years. So you may be familiar with the concept of sovereign immunity or with other particular types of defense that are available to public officials, such as a discretionary exemption. So if the legislative body makes a discretionary decision, they're not liable for that. There's, of course, qualified immunity. You've had a lot of discussion about that. With this type of sort of accident or civil liability that is exercised in tort law. And back in 1993, there was a lawsuit against a municipal public works employee. That case was heard by the court, and the court said, you know, the state legislature really should change the law because people should not be suing individual municipal employees. They should be suing the municipality. And the legislature in 1993 did not make the change. Then a very similar lawsuit came forward against a plow truck driver. And again, the case was heard and the court made the same statement in its decision that state law really should be changed because individual and municipal employees should not carry this type of civil liability. And so at that point in 2003, the state law was changed in 24 VSA 901A, and that requires municipalities to defend and indemnify municipalities. So if there is a claim that a person experiences an injury or an accident or some other damages because of the actions of a municipal employee, the whole municipality corporate is on the hook, which means that is a cash liability for all property taxpayers and fee payers that are served by that local government. And we have had substantial settlements and awards where someone has been injured or has made a claim of damages and the municipality has had to make a substantial payment to that person. So there was one in 2019 in Moortown against a road grader, and that was heard by the court, and the court awarded $300,000. So Moortown had to find $300,000. A year before that, there was a case in a community in Addison County where a person was injured due to a failure of a piece of public infrastructure, and the municipality settled with that person, and the award was over $9 million. Burlington has sort of a well-known one from many years ago that was over 18 million, I believe.
Karen.
Appreciate the examples for this. So one of the things I'm concerned about with this is that, because if it says if the municipality does not qualify for the affirmative defense, that's when this cap would come in place.
Correct.
And so one of the thresholds for having the affirmative defense is that it can't be negligent or reckless disregard. So I'm not seeing that in here at all. So basically, in your example, somebody could be negligent or have reckless disregard and would be able to have this cap.
No, the way that this liability cap works is that, this is my understanding, and this is a question that you should, I think, direct to legislative counsel. But my understanding is that for gross negligence, depending on the outcome or the claim, and certainly for criminal or civil violations, this protection is not available to the person, because the municipality is not bound to defend and indemnify that person. So if a town clerk denies someone's right to vote and they violated their civil liberty, the municipality is not on the hook for the actions of that, or is not on the hook for that illegal action. If a plow truck driver is drunk and hops a curb and causes personal or property damage, that's criminal. Certainly drinking and driving is not an obligation of the plow truck driver's profession or employment agreement with the municipality. So the municipality does not have to defend their actions and would not be obligated to cover any civil liabilities either.
But this would be specific training that they would be following. I guess that I just don't see it explicitly spelled out. And just with the examples you shared, I wonder if any of those are crossing those, that they were gross negligent or what was the other one? Reckless disregard.
I think, again, I would direct that question towards council, but when we've discussed this internally, my understanding is that really depends on the outcome or the claim, whether or not it would be, is that? Okay. But I think at this point, I'd like to move on to discussing how the state enjoys this protection and why it really functions, why it's functional and really serves your constituents and our shared constituents that receive services from state government. So here in Montpelier, we have a number of state parking lots. And the Vermont Agency of Transportation has operated a fluoride reduction program amongst the state employed applicators for many years. So those operators receive training and support from the agency that teaches them how to safely reduce salt and make these types of discretionary decisions, and they do that. So if we have a thaw freeze event in the city of Montpelier and a state employee parks their car in a state parking lot and slips and falls, they would be subject to these liability caps of $500,000 per person or $2 million per incident. Same thing if they pull into the parking lot and they slip their car on ice and they hit someone else's car, same cap for both people involved in that incident. If they are able to safely park their car, exit their vehicle, walk through the parking lot, and then onto the city of Montpelier's sidewalk in the public right-of-way that's maintained by City of Montpelier Public Works staff, and they slip and fall there, then they would not be subject to that incident cap because the state legislature never created the cash liability cap for municipal government. The same thing functions in mountain bike trails, where most of our trail networks and multi-user trails, including here in Hubbard Park, move from private land where there's total protection to municipal land where there's no cap to state land where there is a cap. And so someone could seek remedies if they're injured on state-owned property. They're subject to a limit of what they could be awarded. They can seek remedy if they're injured on municipal land and there is no cap. It's what did the lawyers work out in the settlement, or what does the court decide if it gets that far? So we find this really impractical in the relationship between municipal government and state government to provide really excellent, accessible public services, and that includes salt reduction. Our town governments totally agree with the goals and intents of this bill and this program, which is to reduce the impact of chloride on our public waterways, which is to save taxpayers money in purchasing and managing salt. We went through a salt shortage this year and it really ran up the town highway budgets for a lot of communities. And to save Vermonters money on the damage that chloride causes their personal vehicles and, commercial operations. So we totally support the intent of the bill, but find again that the protection in the bill is inadequate. It's not functional for how town highway departments and public works departments operate. You may have year-round facility staff that maintain public buildings and the space around public buildings. You may have private commercial contractors that respond to annual bids and manage snow removal and sand and salt on roads. And then you may have a public works crew that is seasonal or full-time that manages things like sidewalks and wheelchair ramps, right? So the way that municipalities provide snow removal and salt and chloride application services is really variable. It changes town to town. It changes winter to winter. And we don't find the really precise coverage in the affirmative defense to be like adequate or functional for our communities, which 73% have a population less than 2,500. Most of our town highway departments are volunteers that are appointed at town meeting or elected at town meeting. They may or may not have had the opportunity to take this program or to understand their obligation to maintain this list of records and obligations. But they still want to reduce salt and they still want safe roads, driveways, parking lots, and accessible infrastructure into public buildings. I just want to say, because there was a question about it. So the state created these cash liability caps for the state in 1961. So the state has had some upward limit on their outside liability for these type of civil proceedings since 1961. And then they were raised to the current amounts of 500,000 and 2 million back in 2011. And really, since then, VLCT has been asking for this broad liability protection for all municipal services and infrastructure. But this amendment for this bill would only apply to participants of this program.
Other questions, Ian?
Yeah, so there are two municipalities that are not insured through VLCT.
Currently, or the last time I checked.
Which two?
I think it's Essex City and Burlington.
And do they have access to be insured through VLCT?
Yeah.
So just to clarify, just to walk through kind of like how this would work. If a municipality gets sued by an individual for, let's use the ICE example, but it's not some gross negligence by an individual employee, but it's just, something the municipality did wrong. They contact you, your lawyers come in, and then you guys work with the lawyers for the individual who's harmed, and then you guys pay out for whatever the damages are based on the negotiations, usually resolving at mediation. And the money that comes into play is from VLCT, not from the municipality.
No. And also maybe our attorneys are involved in the defense. In the case, in one of the cases I discussed, they were, but it depends on what insurance product the municipality is using that's provided by VLCT. Many use a combination of participation in the insurance pool and private insurance and self-insurance.
Okay.
And so it depends on the circumstances of the accident, the claim, the location, whether or not VLCT is the insurer that is covering that incident. And possibly the municipality has outside counsel. Most likely they would. A VLCT would sort of participate as needed and support the municipality through the either mediated settlement or their defense. And whether or not a settlement or award is covered by the municipality pool is subject to what their insurance is. So for example, VLCT is the only insurer of municipal dams. I think we have something like 28 municipal dams in the state, including some really big important ones like hydro dams in Swanton and Winooski and in the Northeast Kingdom. There is no private insurer that will cover a municipal dam, and VLCT currently offers maximum coverage of $1 million. And the insurance pool can deny coverage to specific infrastructure. So if there was a dam failure that caused significant personal and property damage, VLCT would cover 1 million and the municipal general fund would be on the hook for the rest.
Is part of what determines whether VLCT gets involved is the amount of the claim?
No, it's the first of all, I don't work for passive and I've sort of reached the limit of my understanding of the agreements between the insurance pool and the municipality. But we are insured. So just like I have Progressive auto insurance and I pay for a certain amount of coverage that may or may not help me through an accident or a claim.
Yeah.
Depending on the circumstances. If I was drunk driving, I wouldn't be covered by Progressive.
Oh, and again, we're talking not outside of the gross negligence of an individual.
Right.
Or something like that. Just the,
Yeah, but it depends on it depends on the insurance coverage.
No, I really appreciate it. I'm just trying to understand it because I think, and I'm not going to testify. My question would be like, I'm trying to understand sort of the difference between state and municipality, and because they're not quite the same, because the state is self-employed or self-insured.
Self-insured.
Okay. So I think when we're talking about something like this, I just want to make sure that I understand and when we're voting on this, that we understand like whose money are we trying to save? Because if it's the municipality, it's a municipality, but if it's an insurance company, I think that changes the calculation, especially when Vermont, the state, doesn't have that kind of insurance coverage.
Well, if you're wondering whose money, when we're discussing municipal coverage in the state of Vermont, it's every municipality currently except for 2. Burlington was in the pool until I think 10 or 12 years ago. And the other municipality has, I think, been out for 5 or 6 years. Every municipality can go to bid and can determine what is the best for them, whether they should self-insure, they should use a commercial insurer, a combination of the 2 or all 3, or join the pool. But VLCT has provided this pool coverage since 1967. So whether or not an incident is covered by insurance provided through passive, or travelers or Progressive or farmers or whatever, or is self-insured, the answer is it's the Vermont public. It's the Vermont public's money, because the VLCT passive pool is money generated by the municipalities which participate in that coverage. The municipalities that self-insure, it's their public funds that are generated by the Vermont public. And then if the municipality is using travelers or farmers to ensure certain aspects of the public services and infrastructure they provide, it's municipal revenues that meet those insurance payments and obligations. So I think in every scenario, regardless of what the claim is and whether or not there's a settlement or the award, and whether or not an insurance company is involved, and if that is VLCT or not, I would say the cost is to Vermonters. They're paying if the if it's difficult to insure Vermont municipalities, which it is, and it becomes expensive, the increase in that rate because of outsized liability to the municipal government falls on Vermont taxpayers, property taxpayers who feed the municipal general fund.
Last question. Do you have, are settlements with municipalities public?
So fundamentally, so for any municipality to reach a settlement agreement, there has to be an action of the legislative body, and that action is fundamentally public information. So the decision to accept the settlement agreement and the amount or other stipulations, like there may be an amount paid upfront and an amount paid through some other way. There may be a amount paid by insurance and an amount obligated to the municipality. And then how the municipality chooses to find the revenue and the resources to meet that obligation, all of that information would be public. The details of the claim may or may not be subject to executive session or Public Records Act exemptions. So it fundamentally is public information. And then it sort of goes through the, 77, I think, current Public Records Act exemptions. And there may be protected private information that is sort of essential or component of the claim in the settlement agreement. And of course, anything that goes through court, any court, like the affidavit that is filed or the sort of originating complaints that go before the court, all the court records are public. So the example I used with the $9.1 million settlement, I know the settlement amount because that's public. The municipality was Brandon. And the initial claim was filed and was public. Yeah.
Is it possible to create sort of a list of settlement amounts for municipalities for like the last 15 years?
I mean, for someone. Yeah, I mean, yeah, in theory, someone could seek 15 years of public record documents from 251 municipalities and over 200 villages, and every court system, and could put that together.
And just last question, is there any way a settlement with a municipality is the amount is non-disclosable?
I don't think that's fundamentally possible, because all components of municipal revenue setting, appropriations, expenses, unassigned funds, and assigned fund balances are all, in all cases, subject to the authority of the voters. It's slightly different in Burlington under their charter, but they have no special exemption to like hide money from the public. And there's good evidence of that. Every municipality has annual audit obligations under Title 24. All municipalities are subject to Public Records Act and open meeting law. So I don't think that a total settlement amount could be reasonably asked by the claimant to be kept private, because the municipality has to find the money, even if an insurer is covering the total award.
Yeah.
Like say it's $25,000 for slipping and falling in a parking garage, and Travelers for Burlington says, we could go to court for $25,000 on your behalf, or we could settle for $25,000 and Travelers will be paying that under your coverage. The municipality, the city council in Burlington still has to accept that decision.
In executive session?
No, the outcome, so the way that Public Records Act works is that the action is not protected by executive session. The action is recorded in the meeting minutes and is subject to discussion. I think you've been in executive session before, so you either come out and you say executive session ended at 11:15 with no actions taken,
Yeah,
or the executive session ended at 11:15 with the action and then it's reported.
okay, that's
Yeah.
really helpful. I was just trying to understand if there's any, so if we were to go and look, we could see all of them, and that there aren't any that are going to be non-disclosed. So that if we wanted to, if we could look and see in the last 15 years.
I think if it were to be protected, that would have to be a decision of the court. I mean,
I don't know, so that's why, yeah.
the municipality has no authority under state law to conceal financial information from the public. Yeah,
Yeah, that makes sense.
yeah.
Tom,
It seems like I just walked in. I was listening on YouTube since the beginning. I think I heard you say on YouTube that the league has been working on a $500,000 cap for a couple of years.
I think at least since 2011. I mean,
Oh, okay.
State law changed.
A cap on all claims, or a cap on what we're talking about here with this bill?
On this specific type of liability under tort law. And
Okay.
so the state law is 12 VSA 5601. So that law was passed or changed to create a cash liability cap for state government
Okay.
for tort claims
Yeah.
in 1961. The
Okay.
league became to exist in
And you're
1967.
looking to match that for the
Yeah.
municipalities.
And this amount of
And
500,
This has been a 15-year battle, I guess you could say.
at least.
As far as that goes. Okay,
Yeah.
no, that's good to know.
Yeah.
And I just want to say, when Representative Ghostland was, talking about, a claim being capped at 500,000, with a head injury type thing, or it could be more than a head injury, something different than a head injury. That's a concern I have also. And with Representative Goodnow's questioning, so Brandon had was it a $9.3 million claim on something for?
9.1 and
Okay.
6.6 was paid immediately.
How much was?
6.6.
So if the league had been successful at some point over the last 15 years for that $500,000 cap, would that claim have been only $500,000?
It depends. It depends on whether or not the municipality was using the passive insurance pool. Some don't, depending at the time.
If they're in the league's pool, would that claim have been capped at $500,000?
It depends on the claim and it depends on the coverage at the time of the incident. So the league may cover, so it's just like your car insurance or your home insurance. Like my home insurance coverage covers up to 750,000, which is way, way, way more than the cost of my home. So I'm like, if my.
Okay, so the
yeah.
league covers.
So it depends on what maybe it depends. So the example I used was a dam. So the league covers up to $1 million. That's a component of our coverage that I know. So damages up to $1 million, the payment would come from the league. Damages over $1 million would come from the municipality in the case of a dam failure or infrastructure issue.
Okay. I'll go back to that 9.1 million. The league potentially would cover part of it. The municipality would be responsible for the rest of it. Would they have an additional insurance rider to cover that, or would they?
They could have they could self-insure up to a certain amount as well.
Well, they're still paying more for insurance. This is a big issue.
Yeah.
And it may be a noble issue, may not be. I don't have enough information. And to me, with the short amount of time we're gonna be spending on this as an amendment, I don't think it vets it enough for me to support the amendment. I don't support the bill. I could have supported the bill if we copy and pasted New Hampshire's, the way New Hampshire does it. I had no problem at all with that. But this is a bigger issue than, for me, it's a bigger issue than just an amendment. And a big reason is what you said, it's been a 15-year struggle, I guess you could say, for the league. And I'm pretty sure once this leaves us, that, you know, we're going to be taking a straw poll, I think, on the amendment, and it's going to go back to environment. This, again, this is a big insurance issue, and this isn't, I don't see this as our purview in judiciary. And as a standalone bill, maybe we would look at it, maybe we wouldn't. It would definitely go to Commerce, because Commerce is the insurance committee. And seeing how the league, again, this is just the way that I think, and seeing how the league is so involved, I think it's a GovOps bill too, or a GovOps amendment. And I can't support the amendment because it's bigger than the time we're gonna have to spend. Is it justifiably a bill for next year? Absolutely. Absolutely. I think it's a bill that needs to be submitted and then go through the, a minimum of what I can see of 3 committees. And again, Representative Goodnow brought up some information, 15, looking back 15 years. We aren't going to do that in the next 12 minutes. And it's a legitimate question that's going to take a lot more time to hash out. So
I want to respond to that really briefly. You talk about the New Hampshire program. New Hampshire has a cash cap for municipal liability in tort law for the state of New Hampshire, as do all states in New England. Some of them go as low as $100,000, and most are significantly older than the current cash caps for state government. So again, this change is very discrete. It only applies to the circumstances of this program having to do with chloride application. So if a municipality is in the program, if they reduce salt, if there's a claim, and if they're unable to utilize the affirmative defense, then the $500,000 cap would apply. This would not change tort claims liabilities for municipalities in all circumstances, although we certainly advocate for that. And there is a bill introduced to this committee last session, Bill H-138, which would make that change. That would, again, be totally consistent with the state's protection, which is $500,000 and $2 million per incident. So I think, is it Connecticut is 100,000? Yeah, I think Connecticut is the lowest, and I think Maine is the highest at 500,000. Yeah.
I mean, as far as H-138 goes, any insurance bills we've ever taken up in here have spoke against us doing it, because I don't look at us as the insurance committee. So, but I think it's a bill for next year, and not spending such a short amount of time as an amendment.
I guess I'll just conclude my testimony, unless there's more questions, by saying, the state of Vermont enacted this protection for itself in 1961. And when the science about the impacts and the negative impacts on Vermonters and Vermont's environment about chloride became clear, VTrans was able to work under that protection and create a program for VTrans to reduce its chloride application. The state of New Hampshire has had that cash liability cap in place for, I think, just as long for both municipal and state government in New Hampshire. And that's a big part of the success and the uptake of municipal applicators in New Hampshire. If you support the intent of the bill to reduce chloride application, including by municipal applicators who maintain more than 4,000 miles of Vermont public roads, that doesn't include sidewalks, and it's, I think, 2/3 more than state maintained roads and highways. Then if you want municipalities to use it, the Booten Amendment would make it possible for them to do that. Without that amendment, that each select board will have to make a careful decision about whether or not it wants to adopt the cash risk against the municipal general fund and their municipal taxpayers, or if they want to accept that risk and participate in the program and reduce salt application. So that's the choice. And like I said, VLCT is really unable to support the program without this amendment. Otherwise, we would be really happy to, because we certainly share the goals of the Environment Committee in putting this together.
So we're going to go to Chris Maley very briefly, but also just to follow up on what Tom was saying, the $500,000 limit exchange with regards to that, it either left me very concerned that somebody's not going to get full payment for their injury, or just confused by how it was explained of who was paying for whom, and that this really is an insurance issue that probably Commerce will need to dig into. But we need to go with Chris Maley very quick. Thank you very much for the testimony. So.
Thank you, Mr. Chair. I appreciate the opportunity to speak in opposition of the bill, and I did hear the brief part of your comment, and I will try to be brief. I think what was lost this morning and what we've talked about is people impacted by catastrophic injuries. I represented the person in that Brandon case. I represented Kate, and what happened in that case was that the town allowed an ancient lamppost to basically be rudderless. It rotted away to the point that it was not stable at all. It was basically just not even attached to its base. So it hadn't been inspected or looked at. It had rusted out from inside. It allowed that to happen over a period of time. And then at some point they said, we're going to fix the base. Before they fix the base, without warning the public, lamppost falls on top of Kate. Kate is rendered a paraplegic. Kate had a life that was dramatically changed at the age of 30. She had significant needs in order to live her life with any dignity. She couldn't go to the bathroom on her own. And so what happened was I brought a claim against the town of Brandon. Brandon hires an attorney. The attorney defends the claim and says, hey, there's things called qualified immunity. There's conservative juries in Vermont. We have some defense to put up. But ultimately, they determined that, yes, it was their negligence. It was the folks that were in charge of keeping the public safe that didn't do their job over a long period of time, and someone got catastrophically hurt. And so then there was this mediation that occurred. There was back and forth, and insurance money was paid, not a nickel from the town. There's all this idea of finding dollars, Moortown finding dollars. Brandon did the right thing. They paid the premiums they needed to pay through the league. And then when an awful thing happened, they took care of the person. And had they not, had there been this $500,000 cap, I would have told Kate, hey, I can't represent you. Your medical liens are going to swallow whole your recovery. There is no claim to be had here. Good luck. And then this idea of who eats that loss, where do those harms go? They go back to the public coffers. We're talking about the safety net. We're still talking about taxpayers paying for this harm. We're not going to leave her on the street. We're going to take care of her some way, but it's going to be the public safety net, not Travelers or not any major insurance carrier who does this. So this idea that a big claim, yes, 9 million plus, that's a lot of money. That happens once in a gazillion years. And I heard Representative Goodnow saying, hey, let's look at the stats. Let's look at the settlements. This was a really outlier kind of case that doesn't happen very often, which is the very reason for insurance in the first place. We do it in towns and we say, we're going to take care of our neighbors. If something awful happens, we will have your back. This $500,000 cap removes that idea altogether so that a town can act in a negligent way and say, tough luck. You have no recovery here. That could be a child. That could be an elderly person. And so I think we just got to think about what's broken here. What's broken in that Brandon case? Brandon's a beautiful town now. Look, they renovated the town. No one's bankrupt. They're doing quite well. They used the insurance they had after having able counsel defend them. The system worked in that case, and it continues to work. The reason the law hasn't changed is because it's not broken. I didn't hear anything about specific cost savings based upon insurance premiums going down based upon payments in Vermont. We all know that Vermont, incredibly conservative juries, modest outcomes. There aren't these runaway numbers. So I don't see the proof that this bill is necessary in any real way by cost savings. And in fact, what would happen is that some people like Kate would get left in a really, really awful situation. As far as the state's $500, I don't have, or $500,000 cap, I believe that there's insurance in addition to that in certain instances that the state purchases and has, and that can be looked at. So it's not as quite as clear as described. But municipalities have defenses to bring in claims. There's still the idea of qualified immunity, which is raised for agents of the town, whether they're acting in a discretionary function or a ministerial. Supreme Court case of 2020, Savetti versus Turner, still has that alive and well for municipalities. It's brought up in most cases against municipalities. So I'm happy to answer anybody's questions, but I know we're out of time. But if anyone has any questions about that case involving the town of Brandon or any other claims, I'm available. Thank you. I appreciate the opportunity.
Any questions for Chris? Yeah, Angela.
Just I had a question written down and then I had to run out and take a phone call. So if it was, but I hear you, but you made the point that I was going to ask the question about. So I want to make sure that it's clear that it seems like maybe inaccurate to say that municipalities have to find the money, because isn't that how insurance works? That's right.
Yeah, that's it. Yeah, that's exactly right. The money that we're talking about, I believe, would be that the towns have to pay premiums. And I don't know the statistics on what's happened with rates, but those insurance rates and premiums are often driven by numbers other than payouts and liability claims. And that's what I'm saying is where, and I think Representative Goodnow was touching on that. Are the companies coming and saying, hey, all these crazy verdicts and numbers in Vermont, we have to increase premiums? I haven't heard that. And just anecdotally being in this line of work for 30 years in Vermont, I don't believe that that's true.
Thanks.
Karen.
Yes, and I asked this earlier, you also mentioned the negligent piece of it. So just to confirm, if this was to pass, there isn't an exception for negligent or reckless, like that would be included in these caps as well.
That's my reading, and my reading is that there's some suggestion that there's a description of this affirmative defense being a nothing. And any attorney can get around it, and it's not really that effective. Well, it's a problem for bringing a personal injury claim, that's for sure. That you have a presumption that the standard of care was met by X, Y, and Z conduct without even going into discovery or finding out what's what. So that's a problem. But yes, that's my interpretation of it. I see that cap as a cap on these claims, and then I've heard that the hope is to have a cap on all claims. And that's going to leave folks like Kate without any ability to access insurance money. We're not talking about municipality general fund money. I'm talking about insurance money that the Vermont League of Cities and Towns has provided for a very long time.
Yeah, and just to put a lid on that one, a question for Michael Grady, that it seems to me, just reading this amendment, that if the affirmative defense doesn't apply because it was gross negligence, the cap would still apply, even if it's gross negligence.
Yes, and I think the reference before is that the municipal need to represent the employee does not apply when the municipal employee is acting outside the scope of their employment. But you can have gross negligence within the scope of your employment. So the language as it's drafted would have the gross negligence.
Well, yeah, one quick question. I was going to ask it before, then Christopher kind of brought it up, and it's a question for Samantha's, is the savings. How much savings would there be as far as insurance premiums go by capping this?
I mean, Samantha Sheehan, for the record, from VLCT, I think that is a question better posed to an insurer. I mean, the way that the insurance premiums are set and adjusted over time are the result of a complex assessment of the outstanding liabilities and the real payments. Like, just like if you get in a car accident, your premium goes up. If a bunch of awards are made across Vermont that cost the pool substantial resources, then the premiums may go up.
Right,
So-
right. And yeah, with that, to me, all the more reason that it needs more vetting as a bill. Because that would be, I have to assume that would be a question. It would be a question that I would ask. If we had, of a witness, and then that information could be found out, so. Thank you.
Okay, thank you. So I will take a motion to find the amendment for the various reasons that Tom has articulated well. To find the amendment, draft number 1.1 to S218 unfavorable.
So moved.
Your second. Okay, all those in favor of finding it unfavorable, meaning that no, yeah, raise your hand. And Coach, are you going to weigh in on this? Are you with us? It's just a straw poll. Yeah, he can have a straw poll. You can, that's fine. All those against? So you're for or against? You're against. You're for being unfavorable.
Yes.
Yes, okay, because you voted for it. But
Okay.
six.
I thought you asked the same question again.
Look, the people who work in municipal government,
6-2,
think it's a good amendment.
6-2-3. Right.
Did you get
Oh,
mine,
I'm
Martin?
sorry, I didn't hear. Where are you on this, Coach?
Against the amendment.
Against the amendment, okay. 7-2-2. All right. All right, thank you, everybody. I think I need to. The committee